According to Section 3 of the Stamp Act 1899, few instruments shall be chargeable with duty of the amount as the proper duty. Respectively, those are every bill of exchange and every instrument, and not duty shall be chargeable in respect of any instrument executed by or on behalf of or in favor of the government, and any instrument for sale, transfer or other disposition, either absolutely or by way of mortgage or otherwise, or any part, interest, share, property, or in any ship or vessel. Therefore, in short, where a deed clearly purports to an agreement to sell and purchase at a future date, the purchase was to be completed and a deed executed. Whether a deed was subsequently executed or not is irrelevant. If a deed purports to be an agreement of sale and law recognizes a distinction between such an agreement and an actual sale, the document should be stamped an agreement and not as a conveyance. In addition, Section 3 of the Stamp Act makes only instrument, that means document, that means legal document liable to duty or liable to do stamp duty, and not the transaction. Next, Section 2, subsection 10 of the Stamp Act 1899 defines conveyance, includes a conveyance on sale and every instrument by which property, whether movable or immovable, is transferred inter vivos. That means every instrument can be included under conveyance. Section 2, subsection 49 of the Stamp Act 1899 states, instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extinguished or recorded. In addition, according to the Stamp Act 1899, instruments have to be written on non-judicial stamp paper of the requisite value. An instrument not duly stamped is not valid, but it is incapable of being used in evidence until it is stamped properly. Section 35 of the Stamp Act 1899 states, instrument chargeable with duty, that is stamp duty, shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered or authenticated by any such person or by any public officer if such instrument is duly stamped. Therefore, for example, where a contract or agreement of any kind is effected by correspondence consisting of two or more letters, and any one of the letters bearing the proper stamp, the contract or agreement shall be deemed to be duly stamped. In short, Section 35 of the Stamp Act prohibits a court from admitting in evidence any instrument which in its view is not duly stamped. This section also prohibits the court from acting on such document. If the court, however, wrongly admits such a document, the appellate court is prevented by Section 36 of the Stamp Act 1899 from calling in question the admission in evidence of such an instrument thought it may have been wrongly admitted. A failure to comply with the Stamp Act may entail penalty, but the whole proceeding should not be vitiated and thrown away for want of stamp. Section 36 states how a document can be admitted in evidence if can be rejected. The provision of Section 36 is mandatory, which provides that once a document is admitted in evidence, it is not permissible for the court to reject its evidence on the ground that it has not been duly stamped. And admitted in evidence means the expression admitted in evidence in succession, the expression admitted in evidence in section 36 means the act of letting the document in as part of the evidence, a result of judicial determination of the question whether it is admitted in evidence or not. That means where document admitted cannot be questioned afterwards on the ground of stamp, an unduly stamped document can take into consideration when admission of instrument were not to be questioned. That means no doubt. Next part is registration of a legal document. We all know that we need to have a written document of any valuable transaction, and it is required by law, but only written document is not enough. In most of the cases, it must be registered too. According to the Section 17 of the Registration Act 1908, where a document is executed to make a document for transaction must be registered. Therefore, when you do anything valuable, you must make a record for the future for reference or evidence to avoid any unexpected situation and also assure future remedy. Exactly that is done by government via the registration process. Government save a copy of your document for future reference and help you get proper remedy if necessary. Registration is an essential part of any document to be legally enforceable. It ensures your documents are real and valid. Without registration, a document is a mere paper which cannot be specifically enforceable before a court. In another way, it can be said that a document without registration cannot be placed before the court as main document or evidence, but it can only be a supportive document which may require collaboration and other legal support. Here is a simple example. Rohim agreed to Karim that Rohim will purchase 100-unit server PC with software for Karim and from Karim, and Karim will deliver it within 3 months. He will pay 25% of the amount, which is 25 lakhs taka at present, and the rest will be paid after product delivery. Being agreed on this deal, they made a deed of sale on 300 taka non-judicial stamp paper, but they never registered this deed of sale. Now, what is the consequence of non-registration? As Rohim did not register the deed on time, he cannot sue only based on the deed of sale to get his money back, nor he can ask for specific performance of the contract. He is also barred to ask for any loss that he has suffered due to his breach of contract. But this could have been the opposite if he registered the document. Now, the registration of the document can be compulsory or optional. The law of registration deals with the registration procedure of document of transfer of property and which documents are compulsory or optional document for registration in eye of law. That means if you are a party of some specific documents, you must be concerned and confirm the registration of the document. The documents are instrument of gift of immovable property, will, lease of immovable property, etc. for compulsory registration. Parties can also register any other documents which is not mentioned in Section 17 Registration Act 1908 and under Section 18 of the Act, which allows registration of any documents, and registration of such documents is optional and depends on the intention of the parties. Therefore, it can state any document not required to be registered under Section 17 Registration Act 1908 is not compulsory to register but may also be registered as optional document.